"Where exactly did you say you got this degree?" he asked, holding the document between two fingers like it was something he'd found on the bottom of his shoe. "Because I have to tell you, and I think everyone in this courtroom deserves to know, I've never seen Yale Law produce someone quite like you." He smiled when he said it. That was the part nobody in that room forgot. The smile. She didn't flinch. She didn't look at her hands. She looked at him the way a woman looks at something she has already decided is not worth raising her voice over. And she said, quietly and precisely, "You're welcome to verify it." He laughed. An actual laugh, short and confident, the laugh of a man who had performed this routine before and found it reliable. Nobody in courtroom 7 of the Fulton County Superior Court laughed with him. In the third row of the gallery, just past the bar, in the section reserved for observers, a man in a charcoal suit had gone very still. He had been still for about 30 seconds, which is not a long time unless you are watching someone decide something. Her name was Dr. Adaeze Miriam Okonkwo. She had 3 degrees. She had published more than 40 peer-reviewed papers. She had been cited in federal appellate decisions in 4 circuits. She had never, in 22 years of practice, been asked to prove that her education was real. And the man who had just asked her, the man with the smile and the document held between 2 fingers, had absolutely no idea who was sitting in the third row of that gallery. In about 8 minutes, he was going to find out. But before we get there, have you ever worked twice as hard to earn something, and then had to watch someone dismiss it in 30 seconds, like all that work was nothing? Let me take you back, 11 years earlier. The morning Adaeze Okonkwo passed the Georgia bar exam, she did not celebrate. Not right away. She drove to Decatur, to the small split-level house her mother had lived in for 29 years, and she sat at the kitchen table, and her mother, a woman named Chidinma, who had come to Atlanta from Enugu with $40 and a nursing certificate, and had not wasted a single day of the 40 years since, made her jollof rice at 10 in the morning because that was what you made when something important happened in that family. Chidinma Okonkwo was the kind of woman who ironed her scrubs before a night shift, who kept her nursing pins in a small velvet box that lived on the top shelf of the closet, not because she wanted to display them, but because they were earned, and earned things were treated with care. She had worked 31 years at Grady Memorial. She had seen everything. She was afraid of nothing except God and waste, and she treated both with the same seriousness. She set the bowl in front of her daughter and sat down across from her and looked at her with the particular expression she had. Not a smile exactly, more like a face that had resolved into something certain, and she said, in Igbo and then in English, because some things needed to be said in both languages, "Now we begin, not congratulations, not you did it, now we begin." Adaeze had understood. She had always understood her mother. She picked up the fork, and she ate, and she thought about what was next. What was next taken 22 years to build into what it was on the morning of the trial in courtroom 7. She had gone to Spelman for her undergraduate degree, studying pre-law and political science on a merit scholarship. She had gone to Yale Law on a full fellowship, the kind the school gave to a small number of students per year, the kind tied not to financial need, but to demonstrated intellectual promise of a specific and uncommon variety. She had graduated 4th in her class. She had clerked for a judge on the 11th Circuit. She had joined a civil rights firm in Atlanta, made partner in 7 years, the first black woman to do so in that firm's 30-year history, and had, in the decade since, built a practice focused on employment discrimination and civil rights litigation that had resulted in 11 landmark settlements and 3 decisions cited approvingly by federal judges whose names appeared in law school textbooks. She was, in the language of the field, formidable. She was also, in a courtroom, something rarer than formidable. She was quiet. She had inherited from Chidinma the understanding that a person who knows exactly what they are doing does not need to announce it. She prepared more thoroughly than any opposing counsel she had ever faced. She filed motions that were surgical in their precision. She cross-examined witnesses the way her mother had taken temperatures, carefully, reading the whole instrument, not just the number. She wore her hair natural. She wore suits that were good but not showy. She wore every day without exception a small gold pin on her lapel. It was an Nsukka University pin. Her grandmother's, not her own. Her grandmother had been one of the first women to attend the University of Nigeria at Nsukka in the early 1960s, in a time when that required a specific and nearly unreasonable courage. The pin was gold, circular, with the university's crest in the center, worn smooth on the back from decades of hands. Adaze had inherited it from her mother, who had inherited it from hers, and she wore it not as a decoration, but as a reminder of where a straight line between three women in one family could eventually arrive. The case in Courtroom 7 was Morrow v. Hargrove Industrial Partners. Adaze represented the plaintiff, a woman named Celestine Morrow, a 53-year-old quality control supervisor who had been terminated from Hargrove's Atlanta distribution facility after 21 years, 6 weeks after she had filed an internal complaint alleging systematic pay disparities along racial lines in the plant's hourly workforce. The defense had argued performance issues. The performance reviews told a different story. Documents told a very clear story, and Adaze had spent 14 months building the kind of case that makes defense attorneys lose sleep. The defense attorney was a man named Prescott Langley Whitmore. He was 54 years old, a named partner at Whitmore, Aldridge and Steck, which was one of the larger management-side employment defense firms in Georgia. He had a record of wins that relied heavily on a particular strategy, controlling the narrative of the courtroom by controlling the perceived authority of opposing counsel. He was good at it. He had been doing it for 26 years. He used language precisely calibrated to erode credibility, not through direct attack, which was obvious, but through the theater of incredulity, through eyebrows and pauses and the performative recalibration of expectation. He had, in those 26 years, used this technique most reliably against women, and most reliably against women who were black, and he had been remarkably successful at it because Georgia courtrooms, for most of those 26 years, had not pushed back. He had done his research on Adaze Okonkwo. He knew about Yale. He knew about the clerkship. He knew about the partnership. And he had decided, with the particular arrogance of a man who had never once been seriously wrong about what he could get away with, that none of it would matter if he introduced enough doubt in the first 3 minutes. He had introduced the doubt during her first witness examination. She had submitted her expert witness qualifications, as is standard for the record, the degrees, the publications, the case history. It was a formality. Whitmore had objected to her expert designation, which was unusual for this stage but within his procedural rights, and the judge, a man named the Honorable Gerald R. Tatum, who was himself 3 months from retirement, and who had, over the course of the morning, been wearing the expression of someone counting the days, had allowed him to question her qualifications on the record. Whitmore had approached the stand with the document in his hand. He had looked at it. He had looked at her. He had performed the specific theatrical gesture of a man encountering something that doesn't add up. The slight tilt of the head, the repositioning of the reading glasses, the held pause, and then he had said it. "Where exactly did you say you got this degree?" And he'd held it between 2 fingers like it was evidence of something suspect. She had answered him. She had answered him clearly and without heat, the way she answered everything, because her mother had told her when she was 12 years old that the woman who loses her composure loses the room, and she had been keeping rooms ever since. But when Whitmore laughed, that actual laugh, short and assured and performing for the gallery, the man in the 3rd row stopped being still. His name was Dr. Jonathan Abiodun Price. He was 64 years old. He was the Dean of Yale Law School. He had held that position for 9 years. He had before that been a faculty member at Yale for 16 years, and before that he had clerked, as Adaze had, for a federal judge, and before that he had graduated from the same institution, first in his class, in a year that now appeared in the school's official history. He had come to Atlanta to deliver a keynote at a symposium on employment law being held at Emory the following morning. He was staying at a hotel 4 blocks from the courthouse. He had a free afternoon, and, because he was the kind of man he was, he had come to watch one of his former students work. He had been watching quietly for 90 minutes. He had heard Whitmore's question. He had watched Adaze answer it. He had watched the laugh. He had sat in his seat for 30 seconds. Then he stood up. He did not announce himself. He simply stood, which, in a courtroom, is a thing that draws attention. And Judge Tatum, who had been watching the exchange from the bench, with an expression that had been moving incrementally from neutral to something else, looked at the gallery. "Excuse me," Tatum said to the standing figure in the third row. "Can I help you, sir?" Jonathan Price said, calmly and clearly, in the voice of a man who had addressed lecture halls and appellate courts and congressional subcommittees. "I apologize for the interruption, Your Honor. My name is Jonathan Price. I am the Dean of Yale Law School. I believe I can offer some clarification on the question currently before the court." The room went silent, not the polite silence of procedure, the other kind, the kind that happens when something shifts. Prescott Whitmore turned. His reading glasses were still on his face. He looked at the man in the third row. He looked at the document in his hand. He looked back at the man. The document he was holding, the one he'd been treating with such theatrical skepticism, bore the seal of Yale Law School, the same school whose current dean was standing 15 feet away. Whitmore said nothing for a moment that stretched. Judge Tatum said, "Mr. Price, you're welcome to approach." Dean Price came through the bar, and a bailiff brought a chair, and Tatum, who had 31 years on the bench and the specific judgment of a man who had seen exactly this kind of theater before, and had very little patience left for it, said, "For the record, please state your position and your familiarity with the credential in question." Dean Price sat. He straightened his jacket. He said, "I am the Dean of Yale Law School. Dr. Okonkwo's credential is entirely legitimate. I remember her admission. I was on the faculty at the time. She was among the most impressive students in her cohort. Her fellowship designation was, in the language we use internally, unambiguous. We do not offer that fellowship to 47 students in a year. We offered it to 6. He let that sit. I would be happy to provide written documentation from the registrar, from the fellowship office, and from my own records if the court wishes. I will note, however, that the credential was already on file with this court in standard form, and has been for the duration of this proceeding." He looked, briefly and directly, at Prescott Whitmore. "There is nothing to clarify," he said, "because there was never anything in question." Whitmore had not moved. His face was doing something that faces do when a performance has been interrupted by reality, not collapsed exactly, but recalibrated in real time, which is its own kind of collapse. Judge Tatum looked at him for a long moment. Then he looked at his clerk. Then he looked back at Whitmore and he said, in the tone of a man who has made a decision, "Mr. Whitmore, I'm going to note for the record that the credential objection is overruled. I'm also going to note that this court's time is not well served by challenges to opposing counsel's qualifications when those qualifications have been on file and are, as has just been confirmed by a rather authoritative source, entirely in order." He paused. "We'll take a 15-minute recess." He struck the gavel. He stood. He did not look at Whitmore again before he left the bench. In the gallery, no one moved for a moment. Then the noise began, the low, spreading murmur of people processing what they had just seen. Adaze Okonkwo stood at the plaintiff's table. She had not turned around during any of Dean Price's testimony. She had faced forward the entire time, with her hands flat on the table and her breathing steady, because she was Chidinma Okonkwo's daughter, and she had known how this was going to end. From the moment Whitmore picked up the document, she reached up and touched the gold pin on her lapel. Just once, briefly, the way you touch something, when you want to remember where you are and where you come from. Then she picked up her legal pad and she prepared for the resumed examination. Dean Price found her during the recess, in the hallway outside the courtroom. He said, "I should have spoken up sooner," she said. "You were exactly on time," he said. "How's the case?" She said, "We're going to win." She was right. What happened in the 3 weeks that followed would be studied in Georgia legal circles for years, but the shape of it was established in the courtroom before recess ended. Whitmore's credibility challenge had backfired so completely, not just atmospherically, but in the documented record, in the judge's statement, in the presence of a sitting law school dean as an impromptu witness to the exchange, that the defense's posture for the remainder of the trial was irrevocably compromised. Juries read rooms. They read what the judge's face is doing. They read the moment when one attorney seems to have lost the thread entirely. Adese presented 3 weeks of evidence. She put Celestine Morrow on the stand for 2 hours on a Tuesday and asked her, question by careful question, to describe 21 years of work, the early shifts, the commendations, the performance reviews that said outstanding and exceptional and a genuine asset to this facility. The 6 weeks between her internal complaint and her termination, the day the HR director came to her workstation with a box. Celestine Morrow answered every question quietly and completely, and the jury watched her the way juries watch people who are simply telling the truth. The payroll records Adese had subpoenaed showed a pay gap in Hargrove's Atlanta facility between white hourly workers and workers of color, averaging $4.17 an hour over a 7-year period. On a 40-hour week, 52 weeks a year, that was $8,673, $60 per year per affected worker. There were 41 affected workers. Some of them had worked at the facility for more than a decade. The math was not complicated. Adese presented it to the jury as arithmetic. She put a number on the board. She said, "This is not an allegation. This is payroll. The records are in evidence. The math is yours to do." The jury deliberated for a day and a half. They returned a verdict for the plaintiff on all counts. The jury awarded Celestine Morrow $840,000 in compensatory damages. They awarded $1 million in punitive damages against Hargrove Industrial Partners. The foreman, when asked about the decision afterward by a journalist, said, "The math was pretty clear. And also, we were in that room. We saw what happened. They had been in the room. They had seen what happened." The Georgia State Bar received a formal complaint against Prescott Langley Whitmore within 2 weeks of the verdict. The complaint was filed by 3 observers, independently. It cited conduct unbecoming of an officer of the court, with specific reference to the credential challenge, the tone of the questioning, and what one complaint described as a pattern of behavior documented in prior proceedings, designed to delegitimize opposing counsel on the basis of characteristics protected under state and federal anti-discrimination statutes. The bar opened an investigation. The investigation, which took 8 months, reviewed 23 prior cases in which Whitmore had filed credential challenges against opposing counsel. Of those 23, 19 involved counsel who were women, 14 involved counsel who were black, 11 involved both. The challenges had been successful, meaning they had resulted in dismissal, continuance, or settlements unfavorable to the opposing side in 7 of those cases. The bar issued a formal censure. Whitmore was required to complete 12 hours of bias and professional conduct training and placed on monitored status for his firm. In the 3 months following the censure's publication, lost 4 corporate clients. 2 partners departed. The firm's name was quietly removed from 2 major industry rankings. In a statement published in the Atlanta Business Chronicle, Whitmore's firm said, "We take these matters seriously and are committed to the highest standards of professional conduct." It was the kind of statement that says nothing and means less. Prescott Whitmore did not give interviews. The case attracted national attention not through a single news moment but through a specific image. A photograph taken by a courthouse sketch artist's assistant who had upgraded to a phone camera, as they all eventually did, showing Dean Price standing in the 3rd row gallery, one hand on the bench in front of him, his face composed and certain. In the frame, slightly out of focus in the foreground, was the back of Adese's head at the plaintiff's table, and just visible at her shoulder was the small gold pin on her lapel. The photograph was published in a legal affairs newsletter, and then picked up, and then it ran everywhere. The headline in the newsletter that first published it was "What the Room Saw." Adese did one interview, 3 months after the verdict. It was with a podcast focused on civil rights litigation. The interviewer asked her about the credential challenge. She said, "I've thought about why it bothered me, and I've decided it's because it wasn't about me. It was about the people behind me, my client, and every client who doesn't have what I have. I have 3 degrees and 42 published papers, and I still had to sit there while someone held my diploma between 2 fingers. What does that mean for someone without all of that?" That's the question I wanted people to leave the courtroom asking. The interviewer asked about Dean Price. She said he was exactly on time. The interviewer asked about the pin. She paused. She said, "My grandmother wore that pin at her own university graduations in 1963 in Nigeria, at a time when women in that institution were new and not entirely welcome. She wore it anyway. Every time someone questions whether I belong somewhere, I think about her walking across that campus." She wasn't asking for permission. She was just going where she had every right to go. In the year following the verdict, Adaeze Okonkwo became one of 3 lead attorneys on a class action filed on behalf of workers at a consortium of manufacturing facilities across Georgia and Alabama, alleging systemic wage discrimination affecting more than 11,000 workers. The case drew the interest of the EOC, which filed a parallel action. It was the largest employment discrimination case in the state's history. It was ongoing. She hired 2 new associates. One of them was a recent Yale law graduate, finishing a clerkship, who had read about the case and written a letter. In the letter, she wrote, "I watched the photograph from courtroom 7, and I thought about what it meant to be in a room where someone stands up. I want to be that kind of lawyer. I want to work for someone who was worth standing up for." Adaeze read the letter twice. She called the woman the following morning. Celestine Morrow used a portion of her settlement to start a small business, a catering operation that had, by the following spring, contracted with 4 corporate clients. She employed 7 people. 4 of them were women who had lost jobs in the same sector, in the same years, for reasons that looked, in the paperwork, like performance but felt, in practice, like something else. She called the business Celestine's. Simple as that. No subtitle, no explanation, she said. People know what they know. The Loretta Mae Washington Foundation, which had, some months earlier, received a significant expansion in its donor base, made a small gift to Celestine's in the form of a startup assistance grant, routed through a West End Atlanta small business accelerator. Neither party was aware of the connection at the time. Some things are like that. Chidinma Okonkwo learned about the courtroom moment from her daughter, on the phone, the evening of the day it happened. Adaeze described it carefully, factually, in order. When she was finished, there was a pause. Then Chidinma said, "Did you eat today?" Adaeze said, "Mama." Chidinma said, "Did you eat?" Adaeze said, "Yes, I had something at the courthouse." Chidinma said, "Come on Saturday, I'll make rice." And that was that. Because the thing had been done and the thing that needed to come next was Saturday and rice. On Adaeze's desk, beside her computer monitor, she kept 2 things: a framed photograph of her grandmother in academic regalia at Nsukka in 1963, and a small card in a simple frame printed in a clean serif font that said, "Now we begin." She had written it herself. She had printed it herself. She had framed it herself 5 years ago when she made partner. And every time someone asked about it, she said it was something her mother had told her once. She never explained the whole story. Some things don't need explaining. If this story stopped you, if you felt something when he held that diploma between 2 fingers and she didn't blink, then please like this video. Share it with someone who needs it. Subscribe if you're here for the first time, and hit the bell. And I want to know, have you ever had to perform your credentials for someone who had already decided they weren't real? Someone who made you prove yourself in a room where you should never have had to? Tell me in the comments. I read every single one. Here's what really gets me, though. Dean Price had a free afternoon. That's it. A free afternoon and a decision to walk 4 blocks and sit in a courtroom to watch a former student work. He wasn't summoned. He wasn't called as a witness. He had no procedural standing. He was a man in a charcoal suit in the 3rd row with no obligation in the world to stand up, and he stood up. And I think about Prescott Whitmore, who spent 26 years doing what he did because nobody stood up, because the room stayed quiet, because the silence was comfortable for some people and costly for others, and the people for whom it was comfortable made the decision, implicitly, every single time, to stay seated. Adaeze Okonkwo did not need Dean Price to win that case. Let me say that plainly. She had the records. She had the math. She had 22 years and 42 papers, and a clerkship and a partnership, and a grandmother who walked across a campus in 1963 like she owned every inch of it. She was going to win. But the moment mattered, not for the case, for the room, for everyone in that gallery who watched a man stand up and say, simply, I know who she is. Not as a favor, not as a rescue, as a correction, as a refusal to let a false story circulate without someone who knew the true one speaking up. Here's my question for you. Not the public version, the real one. Think about a room you've been in, a meeting, a class, a courtroom of your own making, some space where a false story was being told about someone, and you knew better and you stayed seated. What would it have cost you to stand up? Because here's what I believe, having spent a long time with stories like this one. The Prescott Whitmores of the world are not maintained by the Prescott Whitmores. They are maintained by everyone around them who decides, in the moment, that it's not their place or not the right time or not their fight. The Dean had a free afternoon. He used it. Now we begin.